A very good afternoon to one and all, present online and offline. Welcome to the fourth study circle meeting of the GSTPAM. We have our very own chairman of the LNR committee, Sujata Madam, who is also a past president of this esteemed association, who will be taking today's very important topic on safari retreat decision, the implications, and going forward how we are to deal with it. Before we begin, I request President Sir to say a few words.
Thank you, Umang Bhai, convener of LNR committee. Good afternoon. After Diwali, we are meeting. Chairperson of the LNR committee, Sujata Madam, past president, CB Thakurji, Sunil Kushlani ji, office bearers, vice president, Parth Badeka, Rahul Thakur, joint secretary, other managing committee members, all respected members and those who are attending online. Good to see you all. Supreme Court judgment on this safari retreat is a landmark judgment, and we are thankful to Sujata Madam that she has taken this responsibility that immediately to take this subject for the members of GSTPAM. Let me apprise you of all about the activities of GSTPAM. Marathi coaching class is going to be started from 11th of November. Those who have yet to register for their staff and articles, if at all, then kindly register it. Then for Gujarati coaching class is going to start from 18th of November. Good speakers are there, and I feel that chairman to just retweet that it will be reached to, the circular will reach to Gujarat as well, in addition to Maharashtra. If at all any emails or SMS will be required, will be available, will be provided rather. Our TaxCon is there with institute and by association. After Sunil Kushlani's time, at that time TaxCon was there, and we had missed last year. So this year we are going to conduct it on 15th and 16th of November. Keynote address will be Dr. Subramanian Swamy, and other speakers are there. It will be a good program, and it is at WRC, BKC. We are going to celebrate 74th Foundation Day of GSTPAM on 22nd. Actually, it is on 17th of November, but since 2 days back-to-back program are there, we are going to conduct it on 22nd of November at Mulund, and there will be a half-day seminar. It will be 2 lectures are there. Our past President Pranav Bhai and Ashit Bhai will be the speaker, and respective chairman will be Janak Bhagani ji and chairperson Nikita Badega. And there will be an entertainment program. A good live band is there, and they are preparing well. So it is those who wish to attend with the family for the evening program, entertainment program, they can attend that. And those who are already registered, so they will have to extend their time for dinner and entertainment program. And of course, our RRC has been scheduled on 6th of March, 6, 7, 8, 9th of March. So early bird registration is already started, and by 18th it will be increased. So I would like to see that all our members should register before that. Entire hotel may be available to us exclusively. We are welcoming the past president Pradeep Kapadia. With this few word, I welcome you once again all and request our convener Umang Bhai to proceed further. Thank you.
Thank you, President, sir. Now to the pleasant task of introducing today's speaker. She needs no introduction, but Sujata Madam is a BCom, CA and LLB. She has been practicing since 1988, particularly in the field of sales tax. She was the president of the Sales Tax Practitioners Association of Maharashtra, so GSTPAM in the year 99-2000. She was also the president of the Sales Tax Tribunal Bar Association for the term 2002 to 2004. She has addressed various seminars, workshops over Maharashtra on sales tax before professional bodies such as STTBA, GSTPM, WRC, etc. She has also addressed before non-professional bodies such as Rotary Club of Mulund College of Commerce. She has been a regular column writer and contributor to leading journals on sales tax, such as our very own journal, Sales Tax Review. Contributed several papers on sales tax in various seminars, and also co-authored a publication which was published by the ICAI on CST, Central Sales Tax. She was the editor of our review, which is the mouthpiece of the GSTPM from 2014-15 to 16-17. She is a consultant to a number of corporate clients and is currently the president of the Confederation of GST Professionals and Industries since 2017. With this brief introduction, I welcome Sujata Madam. I request President Sir to offer her a small token of her appreciation. Without wasting much time, I request Madam to take it forward. We'll just transfer the computer. हाँ. हाँ.
बुक दे तो बुक उधर से ज्यादा बुक उधर. Yeah. So you just feel better for the viewer. That's it. Do that. Do that. Do that. Kavin. Do रखो. Do that. अगर किस. तो फिर GST ये पीछे होएगा.
Sir?
Yeah. Good afternoon, everyone. It's nice to be in GSTPM to deliver a lecture. I feel like I'm in the family to discuss although professional issues. But it's really pleasure, to be here and have a discussion with you all. The topic today is the analysis, impact, and way forward to the Supreme Court judgment, which has been delivered on 3rd of October, 2024. On safari retreat. Its Chief Commissioner of Central Goods and Services Tax and others versus Safari Retreats Private Limited and others. The judgment has been delivered by a division bench of the Apex Court, Justice Abhay S. Oka and Justice Sanjay Karol. So this is a division bench judgment, and it has, I think, very wide implications so far as the GST law is concerned, especially in case of those who are building immole properties. Because there are certain clauses in the provisions under GST law which allow you the set off. And the provisions block the credit in respect of goods and services as well as works contract which is executed to bring in existence the immole property. They're contained in section 17, bracket 5, clause C and D. And we are basically in this particular judgment on clause D, 17.5D. So sometime back, the Odisha High Court had delivered a judgment in case of the same appellants. And it had allowed the ITC in spite of the fact that a mall was constructed for letting it out. The units in the mall were let out to various tenants. And in that case, the prohibition under clause D was read down, and it was held that the ITC is available in such a case because on the outward supplies, that is the rentals received by the mall owner, they were subjected to GST. So the government was getting the revenue on the rentals which this mall owner was receiving from various tenants. And therefore, he was held as eligible for the ITC. And to some extent, this clause D was read down by the High Court. At the same time, they upheld the validity, constitutional validity of the said clause. Now, against this, the Chief Commissioner has filed this appeal before the Apex Court, Supreme Court. And the Supreme Court has very beautifully dealt with the question in hand because that's a substantial question of law. And it has articulated or elaborated on various aspects relating to this particular problem. Now, let us first understand the facts of the case in order to appreciate the exact problem in hand. The respondents here, that is before the Supreme Court, the mall owner is a respondent. So the mall owner here is a respondent over here. And he had constructed a mall with an objective of letting it out. All the units in the mall were to be let out to various tenants from whom he would receive the rentals. Now, it's not very clear from the judgment whether such agreements with the various tenants were entered into by the mall owner before the construction started or during the course of the construction or after the construction was over. That's not very clear from the facts of the case. But the fact remains that the units were intended to be let out, and that is the primary objective of the mall owner. And he had procured various goods and services such as cement, steel, air conditioning plant, lifts, escalators, whatever. And he had also paid the tax on the said goods and services. Services were also there, architectural services, legal consultancy services, engineering services, whatever it may be. So he had procured them. He had paid GST on the various goods and services out of which the mall was constructed. Now that ITC was accumulated to the tune of 34 crores. His contention was that before the High Court, that since I am going to let out all these units and the rentals are going to be received on which I'm supposed to pay the GST. So there is no break in the chain of the GST or revenue to the government, and therefore I should be eligible for getting the ITC on such goods and services. Naturally, the revenue was of the opinion that he was not entitled in view of the section 17(5)(d), which read as under: the goods or services or both received. Now, this is a prohibition clause. Goods or services or both received by a taxable person for construction of an immovable property other than plant or machinery on his own account, including when such goods or services or both are used in the course or furtherance of business. So no matter you are doing some business, but if that immovable property is used for your own account, not being a plant or machinery, then in that case, you are not entitled to the ITC. That was the contention of the revenue, and they refused to give him, rejected the claim of ITC. But the Orissa High Court in that case held that they were entitled to this ITC because they said that you cannot differentiate between the persons who are building the mall for the purpose of selling it, intended for sale. So if before the construction gets completed, you enter into agreements with various parties to sell off those units, and then you have to pay GST on such agreements because they are liable to tax as per clause 5(b) of schedule 2. And therefore, if the government is getting revenue out of such agreements, then the ITC which is accumulated, that the developer or the person, a mall owner, would be entitled to the ITC in that case when he is intending to sell the units. So why you should differentiate between a person who is using the said units not for the sale but for supply? Because undoubtedly the services of giving the immovable property on rent is a taxable service, and the government is going to get the revenue on that. So why should these people be differentiated as against the people who are constructing it for selling it out only to the various people or prospective buyers? So that was the contention, and the Orissa High Court agreed that you can't differentiate, and they read down 17(5)(d) to that extent and allowed the ITC should be allowed to such people. Now, the revenue was aggrieved, so they came before the Supreme Court. Now, Supreme Court has considered various facets and aspects of this particular question. That was interesting to read this judgment as a whole. the respondents were, you know, challenging this particular, particular contention of the revenue on the ground that the immovable property was intended right from the beginning for letting out on rent. So on the outward supplies, the revenue would be generated to the government. And the second was, it was violative of Article 14 and 19(1)(g) of Constitution of India. So these were the two grounds on which they were saying that we are entitled, in spite of Section 17(5)(d), to get the ITC. They were also relying upon the landmark judgment of Eicher Motors versus Union of India and others, where it has been held that ITC accumulated is an indefeasible right. And once you get entitled to it, it cannot be, just be defeated by way of subsequent legislation. So considering all these provisions and the legal position, it was the contention of the respondents before the Supreme Court that they are entitled to. Now, which are the submissions? Let us go one by one. The submissions on behalf of the assessees, meaning the respondent here. Now, before we start with that, it is interesting to note the observation of the Supreme Court, which the advocates, whoever is, arguing before the courts or even the tribunal, should take a note of. The Supreme Court said that brevity is the hallmark of good advocacy. It would be ideal if parties on one side file joint written submissions. The judges and lawyers are humans. Sometimes bulky compilations and submissions can be counterproductive. So these are the observations of the Supreme Court, that you don't give, and it is our, I think, day-to-day experience also. If you give very bulky submissions, the judges are not willing to, go through everything, because it is sometimes, sometimes it's irrelevant, and, there is a wastage of time and energy on the part of the judges also. And therefore, it can become counterproductive, as has been noted by the Supreme Court. So it is always better to be brief and to the point when you argue or plead your case before the courts. This is the point to be noted by all advocates. Now here, the first defense of the respondents here was, there is, parity between unequals and equals. Now, what is the, see, when you are prohibiting the set-off or ITC on certain grounds, in that case, that prohibition or the class of people or section of people should have some kind of an equality. Now, what is this equality? Is there an equality, or unequals are trying to be, clubbed together and denied the ITC? So it becomes violative of Article 14. Now, in that case, how do they say that unequals are being treated as equals? You consider a case where the mall is constructed for the purpose of selling it to the various owners, various people or prospective buyers. In that case, what will happen? If it happens before the date of completion certificate, he is supposed to pay the GST and also claim the ITC. Okay. But once the completion certificate has been given, then this prerogative is over. Then after, even if he is engaged in a business which is generating revenue, like letting out of the units, even then he is not entitled to any ITC. So this is, differentiating between two similar classes of people. One class is entitled to the ITC and the other class is not entitled to ITC. So they are trying to, putting unequals in a category of equals. And therefore, they are denying the ITC to the people who are actually deserving it. And they are in the shoes of those people who are paying the revenue, paying the GST on the revenue generated by. Now, in this case, there is a twin test of classification, reasonable classification. This has been upheld or established by the Supreme Court in the case of State of West Bengal versus Anwar Ali Sarkar. This is 1952 case. This has not been quoted over here, but I just searched for it, and this is sort of pioneering case where the Supreme Court has established a principle of twin test of reasonable classification. There are two conditions mentioned here. One is the classification must be based on an intelligible differentia. And second is the differentia must have a rational relation to the object sought to be achieved. So if you classify certain people to be denied the right of ITC, then there should be some kind of an equality between them. You can't, club together totally unequal classes on certain. So the differential, the what you call intelligible differentia is the word used by them. So that must be intelligible. That differentiation should be intelligible. Now, on what basis that classification has been done? If it is patently arbitrary, then the courts have the right to set it aside or quash it. But otherwise, the legislature normally has a wide latitude to create the classification, make the reasonable classification, and deny the right of ITC to certain people or certain class of people or sections. Now, it also may be noted here that ITC is not a fundamental right. You don't get it by way of your right granted by the Constitution of India. You get it by way of as a statutory right or a right given by the Act. And therefore, you can't say that even if you say anything or you don't provide me the, the section prohibits the ITC on a certain ground, I will still be eligible for the ITC because it's my right. I've already paid the tax on the previous goods and services, so I'm entitled to the ITC. It's not so. It's a statutory right, and it is well within the jurisdiction of the legislature to impose certain conditions and restrictions so that it becomes available only to certain people, provided they comply with those conditions. Now here, according to the respondents, this differentia was not intelligible. There was no nexus with the objects of the CGST Act. It also, you see, the GST law, when it was brought, or it is now also, we can say it is a destination-based or consumption-based law. And in order to avoid the cascading effect under GST law, it is necessary that you get the ITC on the previous supplies or your inward supplies of goods and services. Now that chain gets broken once you deny the right of ITC to the people who are letting it out. The units are being letting it out as immoral property. Here they have also tried to, and a very novel kind of an argument was brought in before the Supreme Court for the first time, which was not before the Orissa High Court. And that is the expression plant and machinery. Plant and machinery has been defined under the law under section 17(5), below that, as a by way of an explanation. Whereas only clause 5 bracket D uses the expression plant or machinery and not plant and machinery. So this particular distinction or differentiation was brought to the notice of the Supreme Court for the first time. That may be the reason precisely why the Supreme Court refrained from commenting on the question whether the appellants are within the purview of that plant or machinery or not, because there were no comments, elaboration on this particular point by the High Court. So this could be one of the reasons, because they wanted the investigation to be made by the High Court on this particular aspect and give their comments on it, considering the facts and circumstances of the case. Now, this particular aspect was argued by Mr. Arvind Datar for the first time before the Supreme Court. We will go into the implications of that particular phraseology later on. Then it was also argued that when you are denying the right of ITC to such mall owners who are letting it out, then the state is enriching unduly and unjustly on this behalf, because that GST which has been paid on the inward supplies is not being utilized. That amounts to tax paid. It is amounts to tax paid by the dealer, and that is not being allowed to him by way of a credit, and it means the state is enriching itself unjustly. That point was also taken, and it is violative of section or article 300A of the Constitution of India. This was in short, the defense which has been taken by the respondents. It has also referred to the case of Federation of Hotel and Restaurant Association of India versus Union of India and others, wherein the twin test of reasonable classification has been discussed, as I said. And various decisions have been referred over here. They are basically on the twin test of classification, whether the legislature was right in differentiating on this ground that both of them are creating immovable property in different situations. See, clause C and D, there is a basic difference between the two. They are not at par with each other. Under clause C, it is the works contract which is being executed, as a result of which an immobile property is generated. Now, when a works contractor executes such a works contract, he gets the ITC of GST paid on his inward supplies. The developer thereafter, supposing he doesn't enter into the agreement before the completion certificate, then on the immobile property, he may not be paying the GST, but prior to that, he's supposed to pay. So this is a case of works contract, which is separate from a case where I am procuring all the goods and services myself, and then I am appointing a contractor only for the labor job for constructing the entire mall or building or whatever it may be. These are all not on the same footing. And therefore, according to the respondents, the differentiation between the terminology plant and machinery, plant or machinery, in clause C vis-a-vis clause D was necessary. Sorry, it was the contention of the petitioner, I mean the appellant, that is the state or Union of India, that it was a mistake in legislating the act. It was a mistake. So that or should be read as and only. So they have given certain judgments saying that, and there are judgments which say that sometimes, considering the entire interpretation and the context of in which the phraseology has been used, it is permissible to treat or as and vice versa, etc. But the Supreme Court said, it was also brought to the notice that when the model GST law was circulated in the beginning, at that time, both the clauses had plant and machinery. But later on, when the actual act came into existence, it was plant or machinery in D and plant and machinery in clause C. So this can't be a mistake or just an error. So there is an intentional exercise for differentiating between the two phraseologies. So that's what the Supreme Court has upheld this. It says this is not a mistake or inadvertent mistake, which can be. Now, why did you then, it was a mistake, why did you wait for 5-6 years? You're still not, corrected that mistake. According to them, that particular phrase, that is plant and machinery, is applicable to the entire chapter 5 and 6, which includes both clause C and D. But then, if you are differentiating between two clauses in this manner, and there is no, what to say, a proper reasoning for doing this, then it can be assumed that plant or machinery was intentionally put in that particular clause, and it has different connotation altogether. And that connotation has been discussed by the Supreme Court in this particular judgment, which is worth reading and worth applying in our even practical cases also. Of course, it's not that easy because the courts will have to intervene. The GST authorities will never allow you, the ITC, in a case where immole property comes into existence, no matter whether you have, given the on lease or whatever, you have used them in such a way that it becomes a, crucial asset for you to generating revenue, for generating the revenue. Even then, whether it can be considered as plant or not, I think we will always have to, litigate on this matter. In first hand, I don't think any GST officer will ever allow you this ITC on the assets. Sorry. It was also said that under the law, it is required there should be some nexus between the input, inward supplies and the output. And there is definitely a nexus between the two. And therefore, they are entitled to the ITC on such inward supplies. Secondly, Clause D uses the terminology on its own account. Now, this has not been defined under the law, under the GST law. But the court has later on held that it should be taken as used for the personal use on his own account. Here, what the GST authorities are trying to interpret it as, the property has been on account of that owner himself. He is the owner of that property, even though he is letting the units out to different tenants. And therefore, the property remains on his own account because it remains in his own name only. No matter whether he is generating the revenue and he is paying the tax there. And therefore, they are denying the ITC. But here we will go, in detail what is to be considered as on its own account and otherwise. Now, when they were trying to say that this should be considered as a plant, they had also considered a case where the immole property was being used as a hotel accommodation or as a theater, where it has been, designed or constructed in a manner which suits the final purpose of that business. But basically, in this case, they were the mall owners and they had constructed the property for letting it out. But they were trying to equate themselves with the people who were constructing the buildings as per their specifications and for particular user like hotel accommodation but finally the Supreme Court has held that such hotel accommodations or the theater owners, etc., are not allowed for the ITC in view of certain Supreme Court judgments on the very same point. We will discuss that also later. So Mr. Arvind Datar has given a different dimension to the arguments under in this case. The first one, as I said, plant and machinery and plant or machinery. This is the first difference. And then he has said that when you talk about plant and machinery, it has been defined over there. It is specifically excludes the land and building. And therefore, even though the building can be used as a plant, by the specific exclusion thereof in the definition itself, you are not entitled to the ITC. But so far as plant or machinery is concerned, plant is capable of taking into its compass the building as well. So if building can be considered as a plant, then you have a right to claim the ITC there. This is what the plank of argument is. They have referred to the case of CIT Andhra Pradesh versus Taj Mahal Hotel, Sikandrabad. We will, consider the facts of that case also to make it very clear to understand what is the implication of the term plant, because it has not been defined anywhere. Now, whenever the provision is capable of being interpreted in two different ways, then it's a settled principle that the interpretation which is in favor of the assessee should be adopted. So if plant or machinery is a phrase which is capable of being interpreted as including the building as well, where it is being used as a plant, then it should go in favor of the assessee. And therefore also the ITC should be available. The submission of the revenue were accordingly, that or was a mistake, which is turned down by the Supreme Court. Then the intelligible differentia was immovable property, which is acceptable and which has to be understood as being the right way of classification according to them, etc., etc. The principle of equality does not preclude the classification of property, credit, profession, and events for taxation. This is what they are harping on. Then they have relied upon the decision of a Supreme Court, Indore Development Authority versus Manohar Lal and others to bring home a point that or can be read as and can be read as or, etc. Now, this is not found favor with the Supreme Court. They have also said that the term plant has been, defined as well as interpreted under the income tax law, many of the judgments under the income tax law. And according to them, income tax law judgments cannot be considered for interpreting anything under the GST. But you have not defined the word plant. Only plant has not been defined over here. So what is the harm in considering the definition under the Income Tax Act and the judgments? Because Income Tax Act, there is a section called 10(5), which defines plant, and it's an inclusive definition. It includes even books. Now, for the professionals like us, the books also could be considered as plant, provided you show that because the rates of depreciation in respect of plant and building are different. So the assessees are interested in showing that whatever capital assets they have can be considered as plant so that they get a higher rate of depreciation. That's precisely the reason why income tax judgments have dealt with this particular point. Now, why shouldn't the assessees under GST law consider these judgments for the purpose of interpreting the term plant? That's not is not come out very clearly from the arguments of the revenue. According to them, the dividing line is the completion certificate. Prior to completion certificate, yes, you're entitled if you enter into, but that's not applicable if I enter into agreements in respect of letting out of my units prior to completion certificate. It doesn't cover that particular eventuality. It only covers the eventuality where you're selling the unit to someone, prospective buyer. So this is the difference. The Supreme Court has given certain rules regarding the interpretation of taxing statutes in paragraph number 25. I'm not going to read it out because there are nearly A to L principles that you can read out. It's on the classification, whether this is reasonable classification, how to interpret such taxing statute, etc. Now, let us go to the point. Plant and machinery has been defined for the purposes of this chapter and chapter 6. The expression plant and machinery means apparatus, equipment, and machinery fixed to earth by foundation or structural support that are used for making outward supply of goods or services or both, and includes such foundation and structural supports but excludes land, building, and any other civil structures. 2. Telecommunication towers. And 3. Pipelines laid outside the factory premises. So plant and machinery normally would include apparatus, equipment, machinery fixed to earth. Even it becomes immovable, it can be considered as plant and machinery. The Supreme Court has observed that plant and machinery, the expression suggests that it has some element of machinery in it. Plant and machinery. So it has the, even from the definition given in the explanation, we find that it is the element of machinery which is being considered in order to appreciate what is plant and machinery. Okay. But that is not so when you consider the term plant or machinery. So in clause D, what are the exclusion clauses? One is, the exception is where goods or services both are received by a taxable person to construct a new property consisting of plant and machinery. Plant or machinery, sorry. So if you are able to show that you are fitting into the expression plant or machinery, you should be able to get ITC under clause D, where you are procuring the goods and services and using them in an immovable property, but provided that is being used for the outward supply. Now, outward supply does not mean that you do any activity there and that will be considered as an outward. Now, for example, I have purchased an office, which is an immovable property. I've also paid, because it was before the completion certificate, I paid the GST thereon. But I cannot get the ITC thereof because I am doing a practice of a chartered accountant. Now, that office by itself or per se is not being used for the purpose of rendering my services. It is used as being a setting which supports my services, but I am not able to use the same premises for the purpose of rendering my services. So there is a subtle difference between the two. So the line of demarcation between these two cases is very thin, and that needs to be understood before you claim that. The second exception is where goods and services both are received by a taxable person for the construction of immovable property, not on his own account. So this also you need to establish that this is not purchased by me on my own account. This is being used for the purpose of, and it is crucial for me to use the premises for rendering the services or whatever I'm doing. And in that case only you will succeed in getting the yes, the Supreme Court here has explained what is on own account, because this expression has not been defined over here. It says that when it is made for the personal use and not for the service, or it is to be used by the person constructing as a setting in which business is carried out. However, construction cannot said to be a taxable person's own account if it is intended to be sold or given on lease or license. So this is what they have said. Personal use is out of question. There you will not get on his own account. If it is used as a setting, see, every business for that matter, may it be manufacture, may it be rendering of services or whatever, you need some kind of a shed or some setting, some premises from where you can, render these services. That does not mean that it becomes a plant for you. There'll be nothing like a building then. Everything will become a plant. So when you have to distinguish, and that's the crux of the matter, that unless you understand the difference between the two, you will not be able to claim that ITC. So if it is only being used as a setting, then no ITC. If it is being used as a plant, now they have considered certain judicial pronouncements wherein it has been held that the building or the immovable structure is being used as a plant. Now, which are those judicial pronouncements? So that may give you some kind of guidelines, to understand this concept. And that's the most important thing this judgment is providing us. Now, the first one is Taj Mahal Hotel. Now, Taj Mahal Hotel, this is, finally, they have not held in this case. It is a hotel premises. Now, what was the question before the court? The question was whether sanitary fittings which are used in that building, hotel building, they could be considered as plant or not. It was held by the court that yes, sanitary fittings can be considered as, the plant, because the hotel business is such, the customers come to you, and in order to serve them better, you need to have the sanitary fittings and all other amenities, and therefore it was held as a plant. But at the same time, the building in which this hotel was housed, that was not considered as a plant, and that was not a question before them. So there is a distinction between certain goods which can be quintessential for rendering the services, and they can be considered because sanitary fittings, or they have the what to say, they can be considered sort of apparatus, machinery, not machinery exactly, but equipment or whatever, which are necessary for rendering the services. For a hotel business, they are necessary, and therefore they can be considered as a plant. But the building as a whole cannot be, even though it is essential for carrying on the business of a hotel or even a cinema theater for that matter. Now, they have also plant is an expression which has not been defined under the law, GST law, not even under the General Clauses Act. So plant has to be given a meaning which the trade parlance attaches to it. Now, it is the meaning when it is used, those words and phrases must be construed as comprehending not only such things as they signify according to their nature and import, but also those things which the interpretation clause declares that they shall include. The word include is also, include is used in the definition of plant under the Income Tax Act. So that becomes an inclusive definition. So whatever in the commercial or trade parlance, and we are as sales tax practitioners are quite familiar with this concept, that if something is not defined, the article, everything can't be defined under the law. So it has to be construed, or the meaning of it has to be construed as per the trade parlance. What people dealing in that commodity or the concept or transaction are considering that as. So accordingly, the commercial parlance has to be considered in order to understand the implication or import of the word plant. This is what is emphasized by the Supreme Court judgment. The dictionary meaning, what is it? Webster's Third New International Dictionary defines plant as land, buildings, machinery, apparatus, and fixtures employed in carrying on trade or other industrial business. So it specifically includes land and building. So under the common parlance, it's possible that land and building could be considered as plant. It's a dictionary meaning. The case of Anand Theatres, which considered the case of a theater which was specially built in order to, display the movies. Now, we know that in a theater, you need to have a particular arrangement of seats. Normally, when we visit a theater, the fixed chairs are there, which are fixed on a slanting this. And because the last person sitting on the chair should be able to see that, watch the screen. So accordingly, it is designed. But in spite of doing this, the Supreme Court held in Anand Theatre that it can't be considered as a plant. because they have, compared two situations. Which are the two situations? A building where it can be used as a theater without having all this infrastructure. Okay, I'll put some chairs over, like the chairs here. I'll put the screen over here. You can watch the movie. Now, basically you won't call it as a theater, but then it can be used as a theater for watching the movie. And a person who has constructed that theater in that particular manner. So if you allow the ITC to that person and you don't allow the ITC to this person because he is not specifically constructed the theater, this is not going to work. And they said that building which is housing this kind of an activity merely acts as a setting for that business, and it can't be considered as a plant. So therefore the theaters, the cinema hall, the building in which it is housed, or the hotel accommodation, they cannot be considered, and they have specifically excluded. The Supreme Court has said that these two, because these two judgment, Taj Mahal Hotel and Anand Theatre, they have been considered as excluding the theaters and hotel accommodations from the purview of plant. Because of this kind of a comparison, which is possible, and one class of people will not get ITC, the other class of people may get ITC. They didn't want to differentiate that. You may also consider the case of Delhi High Court judgment in the case of RC Chemical Industry, 134 ITR. Mere fact that the manufacture of saccharin would be better carried on in a building having atmospheric controls would not convert the building from setting to the means for carrying on the business. Setting and the means. Just because you have factory premises, which is control, atmospheric controls are there, it doesn't mean that it becomes a plant for that. It just, a condition or an infrastructure created for carrying on your activity. That itself cannot become a plant. They also refer to Rajasthan High Court, Lake Palace Hotels, and simply because some special fittings or controlling equipments are attached for the purpose of carrying on hotel business, it will not take it out of the category of building and make it a plant. So these are the judgments which have thrown light on this particular aspect. But however, the court has held that plant and building are not mutually exclusive terms. Plant may include building in a certain set of circumstances, and therefore applying the functional test or test of essentiality. This test is very important. Functional test or test of essentiality. This is very necessary in order to term anything as plant. So that needs to be seen. A glaring case can be that an English case in the case of Barclay, Curl and Company, 1969 case. House of Lords have considered dry dock as a plant. On what basis? Because structure of the plant was constructed so that dry dock can operate. It operated as an essential part in the operations which took place in getting a ship into the dock, holding it securely, and then returning to the river. So for that entire activity, that structure was necessary. That structure, it was essentially involved in carrying out this activity. And therefore, it was held that dry dock is nothing but a plant. So this is one favorable judgment we have. Then there is another judgment, Victory Aqua Farm Limited. The issue before the court was whether a natural pond used by the SSC, which was specially designed for rearing prawns, prawns is a kind of fish, could be a plant within the meaning of Section 32 of the Income Tax Act. And it was held by 3-judge bench of this court, sorry, in this case, that it is a plant. It is a plant. So that pond, because the pond is very necessary for rearing the prawns in it. Without the water and that pond, the prawns cannot survive. So it was considered as a plant. Then another huh?
Natural it was. It was natural pond.
No, there could be other. This may be natural, but even artificially you can prepare a pond. And I think this activity is also is going on. Huh.
What is the question of that considering as a
But then
plan?
you see, natural, see, when will you claim the ITC? When you make that artificial pond and you incur some expenditure on that. If it is natural, it's given free of charge to you. Sorry?
In this judgment, it is talking about natural. And
Huh.
they have said it is a plan.
Natural pond used by the SSC. Natural pond, yeah, they have said natural pond, but I'm not very clear about whether it's really natural. Because natural pond, you see, then there is no question of claiming any ITC as such. It has to be a pond on which you have incurred some expenditure. Yes.
That's okay. That's there, but I'm sure it must have been done.
Some work must have been done. Yeah. And there is another judgment of Karnataka Power Corporation. In this case, the question was whether a power generating station building is a plant. And it was held that it is a plant. On what basis? The conductivity of the electricity, because this was used for the generation and distribution of electricity. The conductivity of the electricity was through conductors held in ducts called for cable duct system, which were specifically designed for the purpose. The case of the SSC, therefore, was that all these were part of the special engineering works that were on essential part of generating plant, and therefore it was entitled to have the same treated as plant for the purpose of investment allowance under Income Tax Act. The commissioner accepted the correctness of the correctness of the SSC. He held that it was clear that generating station buildings had to be treated as a plant for the purpose of investment allowance. So, I mean, under some peculiar circumstances where the technical requirements for carrying on a particular business are necessary to be embodied in that building itself, and that building is being used. Without that building, it's impossible to carry on that particular activity. In that case, it's possible to say it's a plant. Sorry? They are allowing, why are you saying this? Remanded it back. Yes, yes. But you see, overall, there is a positive thread which is being, no. I have my view on this is different. You see, you have this immole property. Now, immole property being sold to someone else and someone else is carrying on some kind of business, like I say, chartered accountant, some manufacturing activity, whatever. That's a different story altogether. But when that immovable property as a whole is being let out to someone, and that immovable property itself is generating revenue, the service is in respect of letting out that immovable property itself. So I'm using that property in order to generate the revenue. And therefore, it stands on some footing. Of course, as you rightly said, it has been now sent back. But yes, warehouse. They have considered that case also, warehouse and this kind of things, where you can say that the building or that shelter is absolutely necessary. If you don't have the building, I will never put my goods over there, because it has no protection there. So there the warehouse.
Setting of the building.
Huh.
If it is for a theater or
Sir, there is, you see, this argument can go on. There is a thin line of demarcation between the setting and the, yes, and the building which is being used by, here in case of letting it out, although the concept of effective control, etc., has not been discussed by the court, but here I am letting it out. The entire premises is in the control of that person, and he is using it the way he wants it, by way of a lease. I've given it on lease. He's using it the way he wants, and therefore it is on a different footing than just carrying on some activity over there of a different kind. But what? Because of this Taj Mahal Hotel, etc., and Anand Theatres, they have said that we are not going to, change our. ये क्या हुआ?
क्या हुआ?
Secondly, there is a basic difference. I don't know whether you will agree. Basic difference between just letting out the immoral properties to someone and who carries on the business by himself. I have no interference, no intervention in that business at all. But in case of an hotel, it's not just the place which is being let out. I have, couple of services, couple of or bunch of services, which I need to provide to that customer. Then only he will come. It's not that this year room hai, this is the bed and this is the bathroom. This is yours. It's not like that. So you have bunch of services which are supposed to provide.
Or as a plant. So there we are having more something to provide. Mall में तो क्या है, चार दीवारी देना है.
Yeah, but the property itself is being, see, the service, I need various other things, various other infrastructure other than the immoral property itself. You get my point? So the services and the property are being used together.
Control on.
Yeah, and he doesn't have a control. The control is that of the hotel. Now here in case of a lease, that person is in charge of that property himself. That's a thin difference. I mean, I will not say that I am right and you are wrong, but So, considering the ratio of Anand theaters and Taj Mahal hotels, they have, specifically excluded hotel business and theater business. Then they have upheld, of course, the validity of the clause and the constitutional challenge to this provision that it is not, it is void. They have upheld the constitutionality of the provision, and based on various judgments under Article 14, whether this is intelligible differentia or not, what is the basis for this classification, etc., etc. And they have finally upheld it. They have not gone into the question of Article 300A, right to possess the property, and Article 19, because no arguments were made that question. Then there was also a question raised as regards 16.4, because by the time, even if the court says you are entitled to the ITC, I have not claimed it. But I think in view of 16.5 bracket 5, they may not have, what to say, insisted on that particular point. Because even if they have not claimed now, probably they would be able to claim because of 16.5. So that point was also not pressed by them. But anyway, the Supreme Court has said that 16.4 is right and there is no unconstitutionality. So that's also there. Various, I think there's no point in, reading out, because this is all on the constitutional validity of the provision in view of Article 14. It starts from paragraph 57 later on, and there are various judgments. For example, in Hira Lal Ratan Lal versus State of UP, it must be noticed that generally speaking, the primary purpose of the levy of all taxes is to raise funds for public good. Which person should be taxed, what transaction should be taxed, and what goods should be taxed depends upon social, economic, and administrative considerations. In a democratic setup, it is for the legislature to decide that economic or social policy it should pursue and what administrative considerations it should bear in mind. It's completely the prerogative of the legislature. And unless it is, apparently or blatantly arbitrary or prejudicial to some sections of people, then otherwise the courts normally would not intervene in declaring the constitutionality of such provisions. Now, all these judgments, there's no point in reading out the judgment because they're similar kind of thing. in a process, it's possible that injustice may be made to some classes of people who may not get the, but in spite of that, if the classification is reasonable, then it is always upheld by the courts. And accordingly, clause C and D both have been upheld by the court. But only thing, they have remanded the case back to the High Court in order to find out whether, in view of the discussions they have, whether this can be considered as a plant. But this is in spite of the fact that all the facts are before them. They have refrained from giving any clear verdict on that because there were no comments by the High Court on that particular aspect. This aspect was taken up for the first time before the Supreme Court itself. I think that's why that is the precise reason, why it was sent back.
But then
I-
what happened? There was no mall बना.
बट सर वो रिसोर्ट का तो उससे होटल का ही लॉजिक लगेगा
Ah,
होटल का ही लॉजिक लगेगा
Madam, we construct the mall, but now you see in the mall, there are theaters, there are restaurants, there are a lot of things. Because you have a mall with a lot of other things also. So how you?
no, the question is the mall owner. See, finally, what the people. ये क्या होता है? चलता है ना? What is the end use of that property by the lessee is not important here. In the hands of the mall owner, he is letting out the properties to various people and he is generating rental income on which he is paying the GST. That's important. So whether Ah.
He got hit. On the third and on the second floor, he has a restaurant which he is running the restaurant.
No,
On the
no,
first
no.
and second,
He's not letting go.
he's not letting go. He, whenever mall करे ना, first 3 floors are malls.
प्रपोर्शनली आपको 18 के हिसाब से करना है
in 17.2, right. I think that's the, I thank you, all of you, for patience here.
Take question.
Yeah.
And there is one online, but we will take some offline first. If there are any questions.
झाले ना questions आता.
Other questions. Fine.
But any particular thing in your mind is there, you are entitled to it. Where you are sure that you consider the plant.
Planning.
Any other example? So we can understand that.
Sorry? No.
Factory shed तो नहीं है.
वेयरहाउस अकॉर्डिंग
Warehouse can be considered. That is so with every activity, na? आपको office नहीं तो how will you, even your business or our business, how can you carry on without the office or maybe without, some people are doing it from residence, but there is some shed over there, na?
that like madam said that will become a setting
Yeah.
that will become a setting
Despite having that House of Lords judgment, old judgment of UK,
Huh.
Supreme Court seems to have muddled the issue in Anand Theatre and Taj.
No, they have distinguished it. This Anand Theatre and this one, what is it, Taj Mahal Hotel.
They
Right.
have distinguished House of.
Yes. Because they said that you can't compare between two situations where somebody is, constructing the building as per the specifications or for a specific user of that, business, and someone who is, just having a normal building, but putting it to the same user. He's not getting the ITC because he's not designed that building, for that particular purpose. So merely designing a building for a particular purpose doesn't entitle you for that ITC. That's the crux of the matter.
Since we are on theater, one question which we have received online is, what will be the fate of hotels and theaters after this decision? Where special reference is given to hotels and theaters, can they still be allowed to claim ITC?
I've already answered this. No, the answer is no.
So all these people who have kept the ITC, claimed and kept, will have to eventually now reverse.
Yeah.
There are
Or you have to make a case for a larger bench to reconsider Anand. नहीं भाई वही बोलेगा वो कभी भी सेटल नहीं करेंगे
in the factory shed, some of the columns are built for crane, for loading the crane on that. So in that scenario, we are put in as a plant and machinery. Can we say that the columns are part of the plant and we can do the ITC?
इसमें तो क्या है
No, you see, the columns are not put only for the purpose of those cranes. I mean, for in order to construct. I mean, is it specifically for that? Yes. Yes, yes.
इसके ऊपर से खड़े move करते हैं
Correct. Yes.
In that scenario, the columns are put and after on that, what the deduction is there.
The definition of plant and machinery includes all this now. So you will get it.
That, it is the judgment is overturned by the legislature. There is no question.
Loss of 5,000 crore.
होने वाला है
Possible.
होने वाला है
Because they have to merely put or का end करना है उनको.
होने वाला है
रिट्रोस्पेक्टिव नहीं होगा
Yes.
रिट्रोस्पेक्टिव नहीं होना चाहिए बस है ना
But they will make it retrospective.
रिट्रोस्पेक्टिव
they will say it was placed by way of clarification or something but that will again be challenged
So if there are no questions, just,
Rahul.
you know,
Right.
There is a safari retreat, but constructing a mall and people would go. देते remind कर दिया matter, जो later we give you credit. And as Sunil bhai actually pointed out, that this may be amended also by the government. Parliament. But thank you, madam, for giving a wonderful session today. And there are so many online participants today for this session. That itself shows that the topic is burning and quite useful for everybody. And thank you, ma'am, for throwing light on the subject and the good decision. Before I give the formal word of thanks, few announcements. India being a diverse country, hundreds of spoken languages, and we as professionals should learn GST also not only in English but various different languages, including Marathi and Gujarati, and therefore we have arranged, or rather, it's every year we started having GST coaching class not only in English but also in Marathi and Gujarati. The Marathi coaching class will start from 11th of November. We request everybody to join us in large numbers, where we can have fruitful discussion in our own Mathrubhasha. And now, of course, Gujarati also will be starting soon. We are planning to start by the end of November or maybe in December. We are also jointly organizing TaxCon on 15th and 16th of November at the Institute of Taxation of India, where 5 associations, prestigious event of all the associations coming together, where Honorable President already gave the brief of the TaxCon. So kindly come in TaxCon and enjoy the benefit of hearing to stalwarts in the field of indirect tax and direct taxes. And then we have our prestigious event of 49th RRC at Goa. The circular is also there available online. The early bird offer will be ending soon. 23,600 per person is with GST for the early bird. Kindly enroll in large numbers. And lastly, there is a half-day seminar which is being arranged on 22nd of November, along with the Foundation Day program and cultural event. And in the the topic for the half-day seminar is also very good. And we request everybody, be the amnesty scheme which is coming, and the nuances and the circulars which has gone beyond the scope of the section and the rule, and various interpretations, and how to get out of this amnesty is going to be one in a lifetime chance for our clients.
Today's advisory also.
And
New advisory.
advisory.
Today's new advisory.
We are working on it, January तक नहीं मिलेगा sir.
So they are still working on this. The facility was supposed to start on the portal for 1st of November, which is not yet started. They are given the advisory today. But we should be at the end ready with our calculations and working for our clients, so that immediately when the portal starts working, we should be ready. And for that, we have kept a beautiful session on 22nd of November at the after secondary at Mulund. Yes, it is near my house also. Everybody is invited. And that is the whole. And the cultural event is also at the same time. But all are expected to come for the seminar as well as at my house. Followed by dinner. And the fees for that is 1180 for the 750 rupees for the president. With this
Spouse, 250 rupees spouse.
for the spouse. Wow, only for the president. Only president. And with this, now I come to the present task of party. Thanks. Ma'am, it was wonderful to hear you on this topic. And after a long time, such a big judgment has come which can impact the entire industry. Something good has come from the Supreme Court, I feel. And with this, definitely you have thrown or rather opened up the idea of taking a credit in terms of this judgment. And we definitely have to wait for the Orissa High Court to decide on the matter and the facts and circumstances of that case. But as far as us are concerned, we are guided by what man was said. And with this, I request everybody to give a loud round of applause.
कर अजय अजय करो इसको समझेगा नहीं आप कर
I'm not a mic to
small announcement, basically in continuation of education people association. We also have college students coaching activities for GST. So we tie up with various colleges. This is the tie up with MFA college. We have a schedule ready, but some of the dates are clashing with the Marathi. So we have to rework the schedule. But we had started. We had wanted to start on 17th of November, but we have just rescheduled the dates because we don't want the events to clash. Because we are only one this host and it is on the same day. So I'm just announcing that we are already tied up with MMK for this.
with this, I think we can conclude today's very certain. Thank you. Thank you. We are for the national.
Jala jala dikha Nava Shubha Vijage Nava Shubha Shishamage Gahi Tava Jaya Jaya Mata ki
जय